the Children Guardianship and Custody Act. Section 14. Court in making order to have regard to conduct of parent. Where the parent has A. abandoned or deserted his child, or B. allowed his child to be brought up by another person at that person's expense for such a length of time and under such circumstances as to satisfy the court that the parent was unmindful of his parental duties, the court shall not make an order for the delivery of the child to the parent unless the parent has satisfied the court that, having regard to the welfare of the child, he or she is a fit person to have the custody of the child. So if you are the parent of a child and somebody else was bringing the child up, and then you want to order that the child be handed back to you, you must prove to the court that you are fit to bring the child up. Section 15. Power of courts as to child's religious education. Subsection 1. Upon any application by the parent for the production of custody of a child, if the court is of opinion that the parent ought to have the custody of the child and that the child is being brought up in a different religion to that in which the parent has legal right to require that the child should be brought up, the court shall have power to make such order as it may think fit to secure that the child be brought up in the religion in which the parent has a legal right to require that the child should be brought up. Subsection 2. Nothing contained in this section or in sections 12 to 14 inclusive shall interfere with or affect the power of the court to consult the wishes of the child in considering what order ought to be made under this section, or diminish the right which any child now possesses to exercise of his own free choice. Okay, so that seems to be saying that in making an order as to who gets custody of the child, the court, the judge, may get the child's input, ask the child some questions, and so on and so forth. All right. Section 16, definition of court, parent, and person. For the purposes of section 12 to 15 inclusive, the expression court means the Supreme Court. Parent of a child includes any person at law liable to maintain such child or entitled to its custody. So it doesn't necessarily have to be a biological parent. Person includes any local authority, school, or institution. Okay. Section 17, enforcement of orders for payment of money. Subsection 1. Any person for the time being under an obligation to make payments in pursuance of any order for the payment of money under this section shall give notice of change of address to such person, if any, as may be specified in the order, and any person failing without reasonable excuse to give such a notice shall be liable to summary conviction before a resident magistrate, to a fine not exceeding $250,000 or imprisonment for a term not exceeding 3 months. So if you have been ordered by the court to make payments of child maintenance, you must inform the person who you're paying of any change of address. Alright. Subsection 2. Where the court has made any such order, the court shall, in addition to any other powers for enforcing compliance with the order, have power in any case where there is any pension or income payable to the person against whom the order is made and capable of being attached after giving the person by whom the pension or income is payable an opportunity being heard to order that such part as the court may think fit of any such pension or income be attached and paid to the person named by the court, and such further order shall be authority to the person by whom such person or income is payable to make the payment so ordered, and the payment of the person to whom the payment is ordered to be made shall be a good discharge to the person by whom the pension or income is payable. So this is saying that the court may make order for child maintenance and have a portion of that person's income go directly to the person who is supposed to collect the maintenance. Section 7A. Minister may amend monetary penalties. The minister may, by order, subject to affirmative resolution, amend the monetary penalties specified in this Act. Section 18. Principle on which questions relating to the custody, upbringing, etc. of children are to be decided. Where in any proceeding before any court, the custody or upbringing of a child or the administration of any property belonging to or held on trust for a child or the application of income thereof is in question, the court, in deciding that question, shall regard the welfare of the child as the first and paramount consideration, and shall not take into consideration whether, from any other point of view, the claim of the father, or any right at common law possessed by the father in respect of such custody, upbringing, administration, or application is superior to that of the mother, or the claim of the mother is superior to that of the father. Alright, so where in any proceeding before the court, the custody of upbringing of a child or the administration of property belonging to the child or trust, the court, in deciding that question, shall regard the welfare of the child first and paramount. What it says here, it will not take into consideration whether from any other point of view the claim of the father or the mother. Okay, so it seems as if it is saying, here it says the claim of the father or any right at common law possessed by the father in respect of custody is superior to that of the mother, or the claim of the mother is superior to that of the father. It will not listen to them. If the mother says she can bring up the child and the father is not fit, or the father says he can bring up the child, but the mother is not fit. They seem as if this is saying that that's not what the court listens to. The court considers the welfare, or is supposed to consider the welfare of the child first and foremost based on this writing. Section 19, Rules of Court. Subsection 1. Rules of court shall be made directing the manner in which applications to the Supreme Court are to be made, and dealing generally with all the matters of procedure therein, and incidental matters arising out of this act, and for carrying this act into effect, shall be made by the Rules Committee of the Supreme Court. Right. Subsection 2. Rules directing the manner in which applications to the resident magistrates' courts are to be made, and dealing generally with all matters of procedure therein, shall be made by resident magistrates authorized to make rules under Section 135 of the Judicial Residence Magistrate Act. Subsection 3. Rules made under this section may provide for applications being heard and determined otherwise than in open court. Section 20. Saving. Nothing in this act contained shall restrict or affect the jurisdiction of the Supreme Court to appoint or remove guardians. Alright, so that is the Children Guardianship and Custody Act.